Okay, great. Okay, great. Well, thank you everyone for joining us today. My name is David Ullian. I'm joined here by my colleague Brandon Kurtzman. We are attorneys at the law firm Vicente Sederberg LLP. We're based in the Boston office, and we will be presenting today on the law and regulation of cannabis in the United States and in South Carolina. So again, thanks so much for having us. And the way it's going to work is we will present for about half an hour, and then we will open it up to questions for a few minutes at the end. So certainly, if you have any questions along the way, we can try to get them answered after the presentation. Okay, so just a little bit about us before we get into the content of it. My name again is David Ullian. I was raised in Charleston, South Carolina, in West Ashley. I attended Porter-Gaud School, graduated in 2004. Then I attended my undergrad at Amherst College in Massachusetts, and then Boston University School of Law in Boston. I'm a licensed attorney in Massachusetts, South Carolina, and the District of Columbia. I joined Vicente Sederberg in 2016, in April of 2016, so I've been there for a little over 5 years, and I'm currently a senior associate attorney in the Boston office, and I focus my work primarily on regulatory licensing, regulatory compliance, and state and local permitting. And I'll turn it over to my colleague, Brandon Kurtzman, to introduce himself now.
Thanks, David. It's nice to be with everybody today. I'm also from Charleston, South Carolina, grew up in West Ashley, and I attended Academic Magnet High School, went to Lafayette College, and then I went to law school at New England Law in Boston. I am licensed in Massachusetts. I've been with Vicente Sederberg since 2015, and I'm a partner in the Boston office where I focus my practice primarily on state regulatory, national licensing, compliance issues, municipal permitting, and a little bit of corporate work as well.
Okay, great.
So just in terms of sort of a background on the firm, we're a national firm founded in 2010 by Brian Vicente, who's the gentleman on the top there, and Christian Sederberg. Brian's background was as a criminal defense attorney, and he always was advocating for the rights of medical marijuana patients in Denver. That essentially led to the legalization of marijuana in Denver, adult use marijuana in Denver, which was the first state to do so. The firm is a full scale law firm. We offer services basically with everything having to do with marijuana, hemp, entheogens, which are like mushrooms, and everything having to do with these type of businesses. So the corporate aspects, the regulatory aspects, licensing, and ongoing compliance. And right now we have about 100 full-time employees, 40 attorneys with offices in Colorado, California, New Jersey, Texas, Florida, and obviously Massachusetts as well. That's it. So I think that one important thing to sort of understand in terms of context of the discussion about cannabis is the marijuana versus hemp discussion. So marijuana and hemp both come at the high level from the cannabis sativa plant, and then at the next level down, there's a separation between the two plants. Really, the differentiation between the two is based on the level of tetrahydrocannabidiol. It's always very difficult to say that, in the two plants. Marijuana has a higher levels of THC content than hemp does, and it really is. I'll get into in a second. That specific amount of THC creates the classification at both, usually the state and federal level for what the difference between the plant is. The concentration of the THC is mostly in the buds and the flowers of the plant. The plants physically look the same, but one, of course, would have a higher THC content than the other. Dave, do you want to go to the next slide, please? So the big difference too is that so marijuana is federally illegal, whereas hemp recently is no longer federally legal. Both, you see in states, or in some states, will have programs that are dedicated to the regulation of both marijuana and hemp. And as I mentioned before, really the difference from between marijuana and hemp at the THC level is that anything that's above 0.3 THC in the dry weight content is classified as marijuana, not as hemp. So you get into a lot of issues when you are, you maybe buy a seed or something that you believe is a hemp seed, but it tests higher than 0.3 THC, and as a result, it falls into the marijuana category. I'll talk a little bit more on this. David, you want to go to the next slide, please? So, hemp is sort of having a renaissance in the U.S. It's always it's been around for a long time, and it has a lot of industrial uses: paper, clothing, textiles, animal feed. And you also are able to derive a lot of the cannabinoids from hemp that you also are able to derive from marijuana. I think one of the popular ones that a lot of folks have probably heard about is cannabidiol, CBD. You can get CBD from both the hemp plant and both from the marijuana plant. You can also have smokable hemp flower. The buds would look largely like a marijuana bud, but would be under that 0.3 THC content. So in 2018, it was a pretty monumental year for hemp, because the 2018 Farm Bill legalized the cultivation, processing, and interstate transport of hemp at the federal level. And basically what that did was it took hemp out of the definition of marijuana. Marijuana is still classified as a Schedule I drug under the Controlled Substance Act, which makes it federally illegal, and essentially says that it has no medical benefits at all. So by taking hemp out of that category and legalizing it, it's opened it up to basically a freer market, and allowing a lot of states to increase their hemp cultivation and production and processing. So at the highest level, the way it works is that states can submit their own hemp regulations, which have to be in compliance with the 2018 Farm Bill, or if they choose not to do so, then they would fall into the USDA's federally enforced hemp program. So the next slide, David, please, talks a little bit about what's going on with hemp in South Carolina. So South Carolina received its approval from the USDA for its hemp plan in 2020, which allows for the cultivation, processing, and handling of hemp. It was an expansion of South Carolina's previous hemp program. And so basically the way that it works is that farmers and processors and handlers in South Carolina are able to apply for these licenses with the South Carolina Department of Agriculture. Since the adoption of South Carolina's new hemp plan, the farming of hemp has increased from 20 farmers in 2018 to 260 farmers in 2020. So there's no current limits on how many acres you can cultivate for hemp. One of the interesting regulations is that you need to be a South Carolina resident in order to hold one of these licenses. And the South Carolina Department of Agriculture prohibits the manufacturing and sale of human or animal food products containing hemp or derived CBD. So you aren't legally allowed to sell a lot, a CBD, a hemp-derived CBD, animal treat or edible for humans. Even though you basically see a lot of it being sold anyway. I think that what you see is that there's just kind of like low enforcement risk. Interestingly enough, on the hemp front, one of the things that has really presented an issue is that because marijuana and hemp look the same physically, the plants look the same. It's easy to it's easy for law enforcement to believe that a hemp plant is a marijuana plant, and they may confiscate a hemp plant and say this is marijuana. And until it is tested to determine that it's below that 0.3 THC level, it's really impossible to know the difference. My understanding in South Carolina in general is that there's been a huge backup in the state lab's ability to test the two different products. You also see issues recently with the cannabinoid delta 8 THC, which is similar to delta 9. It's similar to delta 9 THC. It can be derived from the hemp plant. It would have below that 3 THC content if it was from a hemp plant, but it has some of the psychoactive, or said to have some of the psychoactive effects that delta 9, which is the primary cannabinoid in THC or in marijuana that gives you the high. So recently, there's been a lot of controversy over whether delta 8 is in fact permissible because it is derived from the hemp plant, and we're seeing ongoing controversy on that front. So that's sort of a high level on hemp.
All right, thanks, Brandon. So that's a little bit about hemp, and now we're going to move back over into the marijuana landscape. So just to give you a sense of where we're at on the federal level, as Brandon mentioned, marijuana is still considered a Schedule I controlled substance under the Federal Controlled Substances Act, and it's been like that since the 1970s. And that essentially means that unless it's authorized for limited research purposes, the importation, possession, use, cultivation, manufacture, sale, and distribution of marijuana is federally illegal. So basically, anything that you want to do with this product is illegal in terms of as far as the federal government is concerned. And believe it or not, with everything we know these days, it's still in the same category of controlled substances as common drugs like heroin, LSD, MDMA, ecstasy, and bath salts. So with all these states who are legalizing it, it's definitely interesting that the federal government still considers it to be that same type of substance as these other drugs. In addition to the Federal Controlled Substances Act, there's a number of other federal laws that would have implications for anyone who happens to be carrying on any sort of cannabis activity. So some of those could be anti-money laundering laws, bank secrecy acts, and RICO acts, which is often used for organized crime and racketeering. And we've often seen some clients who have been faced with RICO civil lawsuits by abutters or other people who are unhappy about having a marijuana business located near them. They often try to file these kind of RICO actions that end up causing a lot of problems. But because of the federal status of cannabis, it is something that can certainly still apply in certain cases. The Department of Justice, the Federal Department of Justice, used to have what was called a Cole memo, which was Department of Justice guidance that the Obama administration in 2013 created, that basically it wasn't law, but it was guidance to U.S. attorneys in various jurisdictions to basically say that any person or company that was operating within the boundaries of state law in terms of medical or adult use cannabis were not supposed to be interfered with unless it implicated certain types of high priority concerns like diversion of product across state lines, or diversion of cannabis products to minors, or any sort of activities that implicated organized crime. If one of those concerns was not raised or involved in a particular person or company's operations, the guidance from the Department of Justice was to let that continue to happen without any sort of federal crackdown. In the Trump administration, under Attorney General Jeff Sessions, he rescinded the Cole memo guidance in 2018. So we were all a little concerned at the time whether there was all of a sudden going to be a massive federal crackdown on patients or other businesses who are lawfully operating within state law. But the reality that we saw was that there really are just only a limited number of financial resources, and it was often left to the discretion of the particular U.S. attorney in each state to decide if they really wanted to go after individuals and people and other organizations that were fully in compliance with state cannabis laws. Another interesting thing that is still applicable is that there have been a number of different types of amendments that are often tacked on to various federal legislation, whether it be a budget bill or other types of legislation that basically blocks any federal funds from being used to enforce federal law against state law-abiding medical operators. And that's particularly important because it specifically only serves to protect medical operators. It does not provide any sort of clear guidance on whether there's any protection for adult use or recreational operators. So this is something that people have been, arguing about and hoping to see in the future. But as of right now, the use of federal funds to enforce the federal prohibition on cannabis against medical operators is currently not allowed. So this gives a good overview of our country right now, and you can kind of see different places where medical and adult use marijuana is legal and illegal. Currently, medical is legal in 36 states, Washington, D.C., and several territories, and adult use is legal in 18 states, D.C., and several territories. And this map on the right side gives you kind of an overview of where we're at. The black or the darkest green jurisdictions are the ones where it's fully legalized, and then the lighter green it goes as to where it's less and less legalized. And you can see that South Carolina is one of only just a handful of states where it is still fully illegal, whether it's medical or adult use, and it's also not even decriminalized. So the trend that we're seeing is that there's marijuana reform coming on a sort of a wave across the country, and then if enough states start to do it, I think we'll really start to see some movement at the federal level. But South Carolina is a little bit behind the curve on this. There are a number of federal legislation bills that are currently pending and have been pending over the past couple of years. You may have heard of some of these in the news, but there is this thing called the Safe Banking Act, which was recently repassed in the Federal House of Representatives. It would essentially allow cannabis companies to access traditional types of banking and financing that every other type of industry is allowed to access, as well as things like insurance, and to take advantage of standard types of business deductions that every other type of legal business in the country is able to access. I think that's probably the one we'll see most likely passing in the next year or two. But there are other potential pieces of legislation like the States Act and the MORE Act, which do, depending on the bill, do a number of different things. Some of which would maybe decriminalize marijuana federally. Others would add actual federal legalization. Others would essentially just let the states decide exactly what they want to do without any federal interference. So there are a number of laws that we are hoping to see pass over the next couple of years. The democratically controlled House of Representatives has continued to pass these types of bills, but unfortunately, the more evenly split U.S. Senate, it's less likely to pass. So it'll be something that I think it will be continued to be debated over the next couple of years. And even President Biden has indicated that he is not in favor of full adult use recreational legalization on a national level. So it would be interesting to see if something were to pass, whether he would sign it. But we have seen indications from the president that he is open to other types of reforms like legalization of medical, federal decriminalization, maybe rescheduling or removing marijuana from the Federal Controlled Substances Act. So I encourage you all to kind of stay tuned over the next couple of years, and we may see some major reforms at the federal level. Okay, and just to make it clear, kind of there are different terms that are often thrown around about decriminalization versus legalization, and this can sometimes mean different things in different jurisdictions. But just to give you a sense of what it means, decriminalization basically means that you remove all kinds of criminal sanctions associated with marijuana activities. So it would remain technically illegal, but if, for example, you were caught with possession of maybe an ounce of marijuana, you would not be criminally prosecuted. And there may be other penalties that could be imposed instead, like civil fines or mandatory drug education or drug treatment, or even no penalties at all. Maybe the law enforcement would just confiscate it, or would even maybe let you go on your way. That's as opposed to legalization, which not only removes all criminal penalties, but essentially sets up a fully legal market and sort of legal scheme for it, where it would be available for any adult 21 plus is what we typically see to possess and purchase and use it, just like tobacco and alcohol. There are some jurisdictions, very few, where they legalize the possession of recreational marijuana, but there's no actual regulated market where people can legally produce and sell it at a dispensary. And a good example of that is the District of Columbia, where for years now it has been legal to possess it, but there has not actually been any sort of recreational marketplace where people can go and purchase it at a store. So next, we're just going to briefly touch on medical marijuana in South Carolina. So as I mentioned, South Carolina is one of 14 states without any kind of permanent medical marijuana program, despite there being overwhelming public support from it. I think I saw a survey recently that mentioned that it's at 72% of the people in South Carolina support having medical marijuana, but unfortunately, there's still no actual legislation in place. Unlike in other states, there's no citizen-led sort of ballot or referendum process where if enough residents or enough voters decide that they want to actually have this become a law, where they can get enough signatures and actually have it be voted on a statewide basis. That's not something that's available in South Carolina like it is up here in Massachusetts, which is how we passed medical and adult use. So it really falls to the South Carolina legislature to actually pass any sort of real legislation about this. And there have been discussions, and it's been under consideration of various forms of a medical marijuana law for the past 5 years. The person leading the charge, and has been over the past couple of years, is Senator Tom Davis, who's a Republican from the Beaufort area. Which is a little bit interesting because we typically see in jurisdictions both at the state level and in the federal level that people who are more conservative and Republican leaning typically are opposed to marijuana reform. When we typically see where it's Democrats and libertarians who are more in favor of marijuana reform. But in South Carolina here, it's Senator Davis who is leading the charge here. There are two current versions of the proposed medical marijuana law that are being considered. They differ slightly. In some ways, they're very similar in that they would legalize the purchase, possession, and use of medical cannabis by a patient who has been certified by a physician as having one of a select number of qualifying medical conditions. And it would set up a regulated marketplace like we see in other states for production and dispensing. And both versions would prohibit people from cultivating medical marijuana at home. Where the differences lie and where a lot of the debate is happening is on exactly what type of products would be available, whether smoking marijuana, smoking flower marijuana would be permitted, what type of devices could be used, such as like vaporizers, what the potency limits should be for the products that are available for purchase, as well as what medical conditions would qualify. There's also some debate and differences about how many businesses would be authorized to be licensed. And the most recent draft I've seen would propose to have 15 vertically integrated companies, with vertical integration meaning one company would be licensed to grow, process, and dispense. And there would be at least 100 dispensaries spread out across the state. So there's been some major opposition over the years, mostly coming from the governor as well as the chief of the South Carolina Law Enforcement Division. But I think we're getting closer and closer, and I'm feeling more and more optimistic that we'll have some form of a medical marijuana law passed at some point over this year or potentially next year. And I'll kick it back to Brandon to pick it up here.
Thanks, David. So I think that when clients come to us and trying to go through the application process or we try to help them identify and get through some of the biggest obstacles that this new industry prevents to our clients. So as David mentioned before, due to the federal illegality of marijuana, access to capital is really I would say the largest impediment to getting involved in this space. It's very capital intensive in terms of property and build out and hiring attorneys, and so not having access to a traditional bank loan, or a small business loan, or some other type of capital that you would typically have if you were starting a new business, makes it very difficult. So you often see, they have to be self-funded. You're looking at private equity, or you're looking at friends and family to raise money. The second big issue that comes into play is finding a property that works. There's still a huge stigma around marijuana businesses, and people feel that they're going to be a blight on the neighborhood. They're going to decrease property values, and so as a result, you see municipalities pass stringent zoning restrictions that maybe limit where you can locate one of these businesses. Oftentimes we'll see setback requirements, 500 feet from 500 feet from a school or a place where children commonly congregate. Sometimes you can see setback requirements from places of worship, and so you have to basically find a property that fits into all of these all these restrictions in order to move forward. Another huge obstacle is that because these are brand new these are brand new programs in states, the application and the approval process can be very long and very expensive. Oftentimes you have both a state component and a local component, whereby you need to get the local approvals for them to allow for the business to be located in that municipality, and then you need to go to the state and then get the state to approve the business as well. And this could involve background checks, submission of plans to show what you're going to do, a series of different inspections, proof of financing. And it really can be very long and complicated. And Sometimes, small mistakes can, really set you back a long time. If it's a competitive process, meaning they're only giving out, a limited number of licenses in a particular state, you essentially have to submit a perfect application. And not only does it need to be perfect, but it needs to be better than every other person or every other group that is applying for these licenses. Another huge obstacle, sort of given that this is such a new industry, is it's new laws and new regulations. They're being passed for the first time. There's no you can look at sort of other states for precedent, but there's not a lot of precedent. I wouldn't say there's one state that has done it perfectly. I think every state has its issues, and it results in complex laws and regulations that can be ambiguous and difficult to interpret, difficult to implement, and somebody who's not an attorney trying to get into this business and understand these new laws can be incredibly burdensome. Good for attorneys, bad for operators. The final thing is because it's such a highly regulated industry, you are constantly under pressure to maintain compliant operations, because that can result in fines and suspensions to your licenses, but it also can serve as an impediment to applying for licenses in other jurisdictions. If you're applying for a license in a new jurisdictions, oftentimes you have to disclose whether you have any licenses in other states or jurisdictions, and whether you've had any sort of compliance or regulatory issues surrounding those licenses. And if you have, it could that could sort of count against you if it's a competitive process. They may say, oh, they're not a good operator. They had all these compliance issues in this other state. We don't want them. So it's a constant burden to maintain compliance with complex laws and regulations. And a large part of what we do on a daily basis is fielding questions from licensed operators about compliance issues. Can I do this? Can I do that? Is this advertising allowed? Is this packaging okay? And then if they do get into problems with the different regulators, helping them navigate a solution and getting out of trouble. So the really, I think exciting and cool thing about the cannabis industry is that you take an industry, a brand new industry, and it touches on every single area of the law, but within the context of cannabis. And for me, when I first came out of law school, I had a civil litigation and a criminal defense background. When I transitioned into cannabis, I started dealing with corporate issues, administrative law issues with the regulatory agencies that are created. Obviously, you still have the criminal component. One thing that we see in a lot of states that have legalized, and you see that people that have been in trouble for or charged for crimes that were previously legal, possession of, minor possession of cannabis, or sale of cannabis that might be legal now. There's all these issues of how do we get these records, or how do we get these charges expunged or sealed, so that now that it's legal, these past crimes aren't preventing people from getting jobs and getting loans and getting access to federal benefits and things like that. There's civil, there's still a civil aspect to it. There's business disputes that occur, and people are suing each other. There's civil litigation. There's tort liability. There's tax issues are a huge aspect because of the federal illegality. these businesses are taxed as though they're criminal enterprises. So there's a minimization of the type of deductions that you can take, and it's important to have tax representation to make sure that you're maximizing your tax benefits. So land use, I spoke about that a little bit before, finding the right properties. Literally any area of law that you're interested in, there's going to be implications in the cannabis industry. Also makes it really interesting is sort of this interplay between federal, state, and municipal law. Because it's still federally illegal, we're always operating in fear, although not as much fear, that there could be sort of the federal government could come down on this and really start to interfere with state regulated medical and adult use cannabis activity. We haven't really seen this in a while, which is good, and I think it speaks towards the trend towards federal reform, legalization, or decrim, or descheduling, and for some of the things that David spoke to. But from a legal standpoint, it's extremely interesting. Prospectively, it's also interesting to think about the interplay between the federal and state laws if federal legalization happens. What's interstate commerce going to look like? What's international commerce going to look like? Are there going to be federal testing requirements? What federal agencies are going to come in and start to try to regulate this? So these are all unknowns, which are going to have to be figured out, which makes it really exciting from a legal standpoint. And then you see an interplay between the state and municipal laws. The state will pass sort of the high level laws, and then the municipalities will have to comply with those laws, but will try to pass their own laws to regulate the product within their territories. So I think that ultimately what happens is, everything's first impression. There's not a lot of precedent, and we're figuring out things as we go along, which allows us to be creative and think laterally with respect to how to address these problems that have never come up before. And I think that with law in general, which there are people that have practiced criminal law or bankruptcy law for 40 or 50 years. That the cannabis industry hasn't even been around for 20 years, and so this is all brand new, and we're figuring it out, which is pretty great. Everybody is figuring it out as we go along too. So it allows you to get creative with different attorneys and different professionals to tackle all these issues. So so that's kind of just like a high level of where cannabis law is and some of the challenges and how you can get involved in it, no matter sort of what your practice area is or what you're interested in. And you could only do criminal, you can only do civil just within the cannabis space. We have corporate attorneys in our practice, and all they do is corporate transactions that relate to different cannabis deals. So it's been exciting. It's been really fun working on this. Since I got involved in 2014.
All right, great. So that's basically our main presentation. So we'll open it up to some questions if anybody has any.
And a couple of questions.
Yeah, so just you can either unmute and speak up, or I believe there's a chat function where you could post your question if that's easier for some people. But go ahead.
I was more like two unrelated questions, but the first one is, since our country is still dealing with the opioid crisis, it boggles my mind that I can look and see that marijuana is considered a Schedule I drug on par with heroin, whereas opioids are still considered a Schedule II. How did that end up that way, and who decided?
Yeah, and I agree. It really doesn't make that much sense anymore. I mean, the Controlled Substances Act was first passed in the early 70s, and there were certainly some different political considerations that went into that. Going back decades too, I think people had some preconceived notions about what the product was and who were the people who predominantly used it, and it just sort of came to be that it was lumped in with all of these other harder drugs. And again, the Schedule 1, as Brandon mentioned, really means that it doesn't have any sort of medical benefit and there's a high potential for abuse. And as we're seeing more and more that, more research being done, more states passing medical marijuana laws, we're really starting to see that just really doesn't make any sense anymore. And different types of organizations have been battling with the DEA and the FDA and trying to lobby for the federal government to reschedule it, just because it really just doesn't make any sense anymore if you actually look at what it does and how it compares to other potential drugs. But so far, the federal government just has not budged. But and the litigation that has resulted from people trying to force the federal government to change it just has not turned out to overturn it. Oftentimes, the courts defer to experts in the DEA and the FDA, just sort of relying on their medical expertise to make these judgment calls, and things just have not moved on that at all. But again, I really do think that over the next couple of years, we'll start to see some changes at the federal level.
My other question was, if we want to try and advocate for legalization of medical marijuana in South Carolina, what's the best way to do that if South Carolina doesn't allow referendums?
Yeah, so there is an organization, I believe it's called South Carolina for Compassionate Care. I could track it down and provide information to you if you need it, but that's the main kind of organization that's been advocating for passage of a medical marijuana law for years. So they have a website. You can certainly get involved with them. They put on presentations and information to different constituencies all the time. And then, sort of in addition to that, it's sort of the standard types of political advocacy where you call your representative, you call your senator, and you really just try to voice your opinion on how they should decide on this new law that's coming up, to be voted on by the Congress. And I think if enough people make enough noise and voice their opinion, at some point that the representatives will have to listen to their constituents.
Yeah, the Marijuana Policy Project has also been working with the South Carolina Compassionate Cares organization to really reach out to the different representatives to try to get this bill passed. Marijuana Policy Project is a nonprofit organization that has sponsored referendums and has helped work on reform in a bunch of different states. Like Massachusetts, for example. The Marijuana Policy Project was the group behind the ballot initiative that allowed for legalization in Massachusetts, and they do incredible work. So that it's another organization that you could look into and donate to. I don't know if you can specify donation for a specific state, which is why you might want to donate to the Compassionate Cares organization, but it's interesting to go to the Marijuana Policy Project website and see some of the work that they do. They do a summary of all of the different states and where they stand in terms of decrim or legalization, and they've been a great partner for our firm in our reform efforts. So definitely something interesting to check out.
Right. Any other questions? Well, if not, this is our contact information. These are, our email addresses and a link to our website. So if anyone has any questions or would like to get in touch with us, you can certainly find us, and we'd be happy to share this presentation as well as a recording of it with anybody who would like to have it. So thanks again for everyone for joining. And if you ever want to talk about cannabis law in the U.S. or in South Carolina or hemp or anything else, certainly reach out. We'd be happy to talk.
Yeah, thanks everyone. And in the website, we post a lot of blog posts and information about everything going on in the cannabis industry. Just kind of easy to digest tidbits on current events. Obviously, New York just legalized. You see a lot of stuff going on right now in terms of cannabis SPACs, in terms of companies going public. So if we have a lot of good info to familiarize yourself with some of the topics that you may be seeing if you follow cannabis all in the news or hemp it all in the news. So I encourage you to check out the website and look at some of these resources. Educate yourselves, and as David said, if you have any follow-up questions, feel free to reach out to us. We're always happy to talk about this, and we're definitely excited to hopefully see some reform in South Carolina in the near future. So thanks for joining us on your lunch today, everyone.
Thanks so much for coming back to your old stomping grounds. We appreciate y'all taking the time out of your day.
Sure, of course, anytime. All right, have a great day.
You too. Bye.
Bye, everyone.